Good morning, everyone. Thank you so much for joining us for our July Clear Up the Chaos. I'm going to go ahead and kickstart things. Stephanie has a full agenda for us to cover, so I don't want to delay in getting started. If you haven't already, please mute your computer so everyone can hear. And please do feel free to send questions via the chat box, and I'm happy to relay those questions to Stephanie for her to answer. So Stephanie, welcome. We're thrilled to have you joining us again. And I know we were going to kickstart things with you speaking to kind of the I-9 flexibility and it being extended.
Yeah, so right now, if you have employees that are working remotely that you've hired on, you're able to review their I-9 documents remotely. You can do it via video, via fax, via email, and you can continue to do that through August 31st. That may get extended again. And what this means is you can review them without seeing them and putting your hands on them. But once this expires, you're going to have 60 days to actually review them, physically, and that's, you're not to provide the document, you're not required to be a document expert, but just make sure there's no words misspelled. I have an issue where a lot of times with fake Social Security cards, you'll notice that there are some words misspelled on the back. So a lot of employers don't think to look for that. One that tends to be misspelled a lot is the word "isn't" on the back of a Social Security card, and usually that's indicative that it's not a valid social, and it was probably purchased at a flea market or something of that nature, or created themselves. So we just want to make sure that we're doing our due diligence and we don't get ourselves in hot water. So like I said, the Department of Homeland Security is going to continue to monitor the remote working situation throughout the pandemic and with COVID, and they may do another extension, but as of right now, through the end of August, you're still okay if your employees are working remotely. Any new hires just doing a remote review of the I-9 documents for Section 2.
So Stephanie, can you speak to if an employee is working full-time as a remote worker, would they need to, I guess, coordinate a time for that individual to come in and get all of that completed, or are there roles associated with someone working full-time remotely?
Well, once they raise the flexibility extension, once they get rid of it, then you're going to have 60 days to physically view the documents and make any changes to the I-9. What we recommend doing is if you have to make changes to an I-9, take a red pen, draw one single line through what you have to change and edit it from there. Don't ever erase, you never scribble something out, just one single line, just to ensure that you're not trying to hide anything.
Okay, thank you.
So the next thing I want to talk about is, this may not apply to everybody, but if you are a private employer that has at least 100 employees, annually you have to file your EEO-1 report. They've extended this deadline, and the deadline is now August 23rd. So they've given you roughly a month and a couple days extension. If you do not have 100 employees, but you have federal contracts and you have 50 or more employees, you may also fall under that. If you have any questions, I can email the guidance to you on who has to file an EEO-1 report. Also, depending on the type of entity you are, you may have to file a different type of EEO report, EEO-3, EEO-4, depending on if you are a school, a local municipality, a water district, something of that nature. Those have different filing requirements as well. And we can talk to you and let you know if you meet that threshold, because there's quite a few different thresholds. It can depend on the size of your federal contract. Sometimes if you're a subcontractor, you're going to fall under that. So there, like I said, there's a bunch of different requirements on who has to file it. But if you're just a private employer and you have under 100 employees, you don't have to file it. So that does not apply to you. So I'm sure a lot of you guys are having problems with employees wanting to come back to work. They got used to working from home. They feel safe at home. They feel, that they're able to keep their work environment much more regulated and avoid, any type of interaction with somebody with the COVID virus by continuing to remote work. Well, there's a couple things that we want to look at here in getting people back to work. Under ADA, we're going to look at what's called the essential job functions. Say you've got somebody that is normally a receptionist or a secretary for you, and they have started working remotely, transferring the phones to their cell phone, or giving them a company cell phone to respond to and just send out messages. Well, if they're a receptionist, they're a frontline worker at your business. So they're going to be that person greeting people that come in. So an essential job function of that person is to be present in the workplace. So there's less of a need to look at reasonable accommodation. And the only time we want to really look at reasonable accommodation is, does this employee have an underlying health condition? Are there medical reasons that we should, allow them to continue to remote work? There are some businesses that half of their workforce will never come back to the office. They've already been in discussion. They will continue to remote work. Office spaces are closing up. People are letting their leases go. The workplace has changed, and it's not gonna, it'll probably never be the same. But we can also help you guys come up with ways to bring your employees back to work, especially ones that don't fall under the need for reasonable accommodation under ADA. They don't have an underlying health condition. Also, with regards to underlying health condition, it may be a point that you have to look at a little bit of FMLA and how that could, come into corporation with them needing to work remotely. But like I said, you really want to focus on their essential job functions. And if their essential job function shows that they need to be in the workplace, then there really is no reasonable accommodation that you can give them, because it's kind of like an employee who cannot show up to work at all. You can't accommodate somebody who can't come to work at all. There's no possible way to do that. You can accommodate them by allowing them more break times, leniency and time off for doctor's visits, things of that nature, allow them to wear a mask when nobody else is wearing a mask. There's all different ways that we can look at to accommodate an employee to make them feel safe to return to the workplace. So if you are one of those companies that are having that struggle, which many are, and it's not unusual, we can talk about different reasonable accommodations that can be done to help them feel safe to return to work. So we're also looking at CDC coming up with more and more regulations and recommendations for the workplace to operate a safe working environment. We're going to continue to keep up to date with any guidance that they're going to be providing on that. And I can get it to Elizabeth and she can disseminate that information out to everybody so that they're, in the loop on that. We're looking at more changes in mask mandates, more changes in vaccination mandates. Obviously, Texas employers fall under a slightly different regulation with Abbott passing the vaccine information to where you can't inquire of employers. Employers can't require of customers about vaccine status. They risk losing contracts. What people don't realize, they even risk losing licenses. So say you have a wholesale tax license, you can risk losing that in the state of Texas right now if you are inquiring of your customers this information. While it's not yet illegal to ask employees about their vaccinated status, we highly recommend against that at this point, because we feel that there's going to be more clarification coming out. The only reason the Methodist Hospital lawsuit was thrown out is because of the strategy they used. They used the Nuremberg Act, and with that only applies to federal institutions. And Methodist Hospital is a private employer, so there was no applicability for them to take that route. However, the lawsuit's already been refiled, and we anticipate to hear more guidance on what's going to happen with Methodist making that requirement, because they ended up having 134 employees that they either terminated or the employees resigned. So that's a huge thing, and employers all across Texas are watching that through the court system to try and find out what's going to happen there. So we'll keep you guys up to date with that as well, because whatever the courts decide, that's going to set a precedence, and all employers are going to need to pay attention to that precedence and change their policies accordingly. Obviously, if you are in the healthcare industry, if you are in a nursing home or a long-term care facility, you're exempt from those regulations. You are able to require that, the mandatory vaccinations, but you have to think of the conditions that you're working in. Your job is to heal people, not to give them COVID. So that's why they're going to be exempt from that regulation. So with that being said, another big thing that the current administration is cracking down on is misclassifying employees. So this is huge. Most people think they can circumvent a lot of laws by stating, hey, they're an independent contractor, or they'll call them 1099 employees. Well, that's an oxymoron. There's no such thing as 1099 employees. You're either an independent contractor or you're an employee. What that's going to boil down to is who has control of your day-to-day operations. If you are working for somebody and they're telling you what time to get to work, you know, what to do, how to do it, or they provide any tools, more than likely you are not an independent contractor. In very rare occurrences could you be, but if they do the ABC test or they do any of those other tests, you're not going to be an independent contractor. So I think that any employers right now that do have independent contractors, they need to go through, do a job description and find out, are they truly an independent contractor? The reason it's so important to go back and look at the classification is because back in the day, as of, well, 6 months ago, we had what was called the good faith effort. So for years and years and years, if you had employees misclassified and you realize they were misclassified and it was an accident, or maybe it was intentional and you just want to make things right now, you have the opportunity to go to the Texas Department of, not Texas, the Department of Labor or Texas Workforce Commission, tell them that you misclassified employees, but that you're making a good faith effort to correct the misclassifications and classify them correctly. So as long as you paid them back wages that you owed them, they waived the penalty. There's no waiving of the penalty anymore. Marty Walsh came in, he's the new Secretary of Labor, and he completely got rid of the good faith effort. So even if you know you're doing something wrong and you try and fix it, the Department of Labor doesn't care anymore. You're going to fix it, but you're also going to face penalties, fines, and then of course you're still going to have to pay the back wages, which with a good faith effort, you would have done that anyways. Just to give you an example, the state of New Jersey yesterday just came out with some new guidance on independent contractors. They've also put $1 million towards new investigators to randomly go into employers and review their document and their employee classifications so that they can start drumming up fees and start initiating more audits. And these are going to be unsolicited visits to employers. So obviously if they show up, you have roughly 3 days to tell them, can you come back in 3 days while I get all my information together? So this is just one state that's cracking down on it. Other states are going to be doing it too, because what it is it's a way to get money from companies to help replenish, you know, all the monies the counties and the cities and the state has depleted during this pandemic. But they're going to look at it anyway. You know, it's our government. They want every dollar we have. So that's going to be a huge thing. If you ever have questions about how your employees are classified, or say, hey, we have this one employee and we've always called him an independent contractor, but I'm not sure that he is. You know, that's something that you can call us and we can walk you through the next steps that you need to take in order to reclassify the employee correctly, how to sit down with the employee and discuss what's going on. Because if you have misclassified, you may owe them back wages because they are subject to overtime regulations under FLSA. But like I said, we're a phone call away. You can send an email to Elizabeth. She can forward it on to me and we can get you guys on the right path and how to handle it. We also have some law firms that specialize in employment law, and when employers do misclassify employees, that if it is, you know, a widespread issue, we can get them looped in and they can give guidance as well. And as part of your relationship, you know, with NCW is you get to utilize us, and we in turn have law firms that can help assist you guys as well with free phone consult.
So Stephanie, you would have to pay the back wages, and then is there a fee on top of that for doing it incorrectly? Like, what does that fee look like?
The penalties and the fines are going to be based on how widespread and severe, whether it was something you did on accident, whether you knowingly misclassified them, and also who's doing the investigating at the time. I know there's caps on the amounts of fines, but they're going to go back 7 years. They're not just going to go back to past due pay periods. They're going to go back 7 years, and you're going to owe a fine for every pay period that person was misclassified and was not subject to FLSA and overtime. So you're going to have kept together time records, because they're going to look back at each pay period. So, and it's an employer's responsibility to keep accurate time records. If you have somebody misclassified as an independent contractor who kept their time records, that independent contractor could be having a piece of paper on the side where he's just marking times down. And who are you to dispute it unless you kept, time records that are accurate? So he could say that he's owed 30 hours of overtime every single pay period for the past 7 years. And you'll pay a penalty on that unless you can prove otherwise that he didn't work those hours. So it can be huge. I mean, it's going to be a big thing, and they're pushing towards these investigations. So it can be scary to think about because it can make or break a company depending on how widespread it is.
Yeah. Okay, thank you.
So I want to move on to the biggest one, and I hope you guys have questions on this because this is huge. This is probably one of the most far-reaching executive orders to date of this administration. Basically, any of you guys that have non-competes in place for employees, they are asking the FTC to ban or strictly limit any non-compete agreements. Keep in mind, this is going to extend to non-poaching agreements as well. So unless you have automatic proof of an employee approaching another employee and getting him to move on to a different company with them, there's no anti-poaching agreement that's going to stop that, because you would have to have direct proof. Now, one of the things that the state of Texas has always said is it's very hard to enforce a non-compete. And that's because Texas passed a law called the Texas Free Enterprise and Antitrust Act of 1983 that essentially states anything that changes an employee's ability for mobility and to make more money is something that we deem as illegal. Now, the Texas courts have gone back and they've said, if we limit this to scope, if we limit it to a geographic area and we give it a time limitation, then it may be legal in the eyes of Texas law. Problem is, most people who have non-competes can't afford to take it to court, hire an attorney, and fight the non-compete. So they just go with it. Well, unfortunately, now the new administration, what they've done is they are calling it, sorry, I wrote it down somewhere. They're calling it 3 bullet points in order to aid the passing of the Protecting the Right to Organize Act, which is currently waiting to be passed through Congress. I know last time I was on here, we talked about the last executive order, which is encouraging, it created a task force allowing employees to unionize, encouraging employees to unionize, and giving them advice and guidance and financial assistance in forming unions in private employers. So this is going hand in hand with that. So not only are they continuously pushing to drive the employees to unionize, we'll find out in September additional information on that, because that's the deadline that they gave the task force to come up with the exact ways that they are going to assist employees in unionizing. You could be a small employer and have 2 employees, and those 2 employees unionize, and they have all control over anything in the company. You can't terminate them because that's retaliation. You can't change their working conditions because you'd have to go and get it. You'd have to go through arbitration. And in order to change the working conditions, they would have to agree to it. And you're going to spend a ton in attorney's fees. So, I mean, this is a huge thing. So not only that, but now they're pushing to ban or limit non-competes. They're going to also ban unnecessary licensing. So say you are a medical facility and you hire CNAs, which are certified nursing assistants. They're essentially stating that they want to get rid of the actual need for a license for certain, positions and just allow on-the-job training. Whereas most facilities, they want the license and they want the on-the-job training, but your license in Texas is not going to extend to Louisiana. So say you're in a military family or you're a military spouse, and every year or so you're moving to a different state and your job is a CNA. Well, every state you move to, you'd have to get an occupational license in that state as a certified nursing assistant. And they consider that to just be suppressing a person's ability to move from state to state and get a new job. and that it's unjustly targeting people that move around in industries because of their spouse, which doesn't make much sense to me, because they want to talk about, you know, having everything equal, but then they're treating something as unequal. So our government's an oxymoron still, and it always has been. But the biggest thing is they're also going to prevent employers from using third parties to discuss wages. So say I'm a high-end executive and I want to move to another large executive firm. And normally the way it goes is you tell them what your salary requirements are. Then that company calls over to the other company and gets your wage information from what you were making. They can't do that anymore. That's now illegal. So that's going to cause a bunch of issues too, but it's going to be beneficial in the eyes of the government, because it's going to create competitive wages. Instead of you offering them, you know, $1,000 more than what they were making, you're going to actually make them an offer to pay them what they're worth, or what you feel they are worth based on their education and experience. And that's huge. And that's going to prevent discrimination in the workplace too, whereas they're going to hire the person who is making less money because it's going to cost them less, rather than hiring a qualified candidate. And that's why a lot of states have also passed ban the box issues, where employers cannot inquire about anybody's criminal history until they've given them a conditional offer of employment. And only then can you run a background check. And only then can you look at things in the background check that are actually applicable to the job they're going to be doing for you. Whereas obviously anything that's aggravated or sexual in nature can automatically disqualify you from a position. You'd also want to look at all the details of the conviction. So I can go on and on about this for sure. One other thing to keep in mind, there's 72 different points in this new executive order, and they're talking about things from reimbursement of luggage fees by travel companies if they lose or delay your baggage, all the way to, this is something that's going to probably affect larger companies. They are going to look at any mergers that have happened in the past and where previous administrations didn't question the mergers and the legality of the mergers under FTC guidelines. And specifically, they're going to be targeting web-based mergers such as Amazon, Facebook, things of that nature. And they're going to follow a lot of look at some antitrust stuff. So that's one thing that's going to be happening. And they're also going to establish rules on the surveillance and the accumulation of data. This is going to be important for anybody here. If you are collecting email addresses for a newsletter blast that you send to your clients, make sure that you're getting something from them stating that you can collect their email address and use it for marketing purposes. Even if you're just not selling it to anybody, you're using it for your company, it's part of, it can violate what's called the CAN-SPAM Act. And you want to ensure that you do have permission and authorization to collect that data from your clients.
So Stephanie, is it enforced now that an employer can't disclose wages?
I'm sorry, what?
Is it in force right now that an employer can't disclose wages?
So what happens is employers tend to report wages based on work type, not directly attributing it to a specific person. And third parties then sell that information to other companies. They want to get rid of that third party that's able to do that. If you sign off allowing your employer, your current employer, to disclose that information to somebody that you're applying with, then they can disclose that information, but they need to make sure that they have a disclosure from the employee. They're going to end up taking that away. So right now, if you are a CDL driver, on most applications for a CDL driver, it will ask you for starting wages and ending wages. Then that information is sent over to your previous employer or your current employer if you're looking for a new job, and they will confirm the information on there. They'll confirm the dates of hire. So what we've done is we have taken off the wage information off of our generic applications for CDL drivers, because it needs to be based not on the wages they made, it needs to be based on the job they did, their safety and performance history, and their drug and alcohol history. And all that is information that per federal standards must be released when you are a CDL driver. But that's just an example. A lot of applications will ask for wage information. Doesn't mean that you have to provide that, but eventually it's going to get to the point where they're going to have people take that off the application and not inquire about wage information. And eventually it came very close to passing, but there's this thing called the Pay Equity Act. And what it does is it's going to create transparency where employees will be able to eventually see if they're making the same amount. Say if I'm a female, and I am, if I'm making the same amount as my male counterpart, and I have the same amount of experience and education, but he's making, $5 more an hour, or $10,000 more a year. The Pay Equity Act is going to bring a stop to that, and we're expecting that to be wrapped up into one of his next executive orders pretty soon here, because it's something he is adamant about passing. Marty Walsh, the Secretary of Labor, is adamant about passing that as well. So there's not going to be much wiggle room for employers. They'd have to justify the reason that a male was making more than a female, or a female was making more than a male, or somebody who is African American making more than somebody who is Caucasian, or Caucasian versus Hispanic. All of it is going to be pay equity. So they want to streamline it to where everybody is clearly making the same, only based on experience.
So is that what the executive order is called regarding the wages, this Pay Equity Act, or is there a different?
The original one was the Pay Equity Act. It stalled. So they're going to look to wrap it up in an executive order where it can't be stalled, because an executive order is simply signed by the president and it's pushed through and there's no vote on it. Whereas with the Congress Act, it passed the House and then it stalled in the Senate.
Thank you.
But we can look towards more executive orders governing employers. And also, I would say in the next couple of months, we're going to get some more clarity from the FTC on what they're going to do to limit or even outright ban the non-compete agreements. What I see happening is Texas, like I said, is already really hard. You have to specify, okay, I'm in the landscape industry. You have to be somebody that has information, trade secrets, customer data, things of that nature. Otherwise, they don't need to be under a non-compete agreement. Somebody who is just an hourly worker for you should never be under a non-compete. These need to be stuck to people who have access to company proprietary information and can go to a competitor and use them. But your non-competes, you're going to want to look at the geographic area that you're limiting it to. It can't be too broad. You're going to look at the time frame. Anything more than 6 months is deemed excessive for the most part. And you're not going to find a lot of lawyers that are going to want to write a non-compete for, I would say at the max a year. And that's going to need to be somebody who is going to be probably a C-level executive at the company. But at the same time, a lot of those C-level executives, as part of the negotiating ability for the job, is they opt out of being held to a non-compete standard, but they promise to stay at the company for a certain amount of time. And then you're going to want to look at the industry. Obviously, if I'm in the landscaping industry and I'm their head salesperson and I go to work for a fencing company, those are two different industries. Unless that fencing company specializes in fences made out of landscaping materials such as hedge bushes, there'd be really hard to prove the applicability and the conflict of interest there. So like I said, you would want to look at what your current non-competes are, because what they're going to do is they're going to start breaking down current non-competes. They're going to make it easier for employees to fight non-competes that they're under.
Thank you.
Also, one more thing that I do want to mention is there was another executive order signed, and it is mandating some diversity, equity, and inclusion training for any federal contractors and federal employers. We feel that this is eventually going to be passed on to the private employers as well. So starting to come up with a diversity, equity, and inclusion plan is something that we highly recommend, because it's going to not take overnight to enact. You're going to have proof of training. You're going to have to find a good training program. We can come out and do training as well. We're actually currently developing a training program on this. But like I said, it's a brand new federal requirement that they are going to eventually pass down to private employers. Usually what they do is they make government workers abide by it, and then they pass it on to private employers once they show that government employees can be held to that standard as well. So that's something to keep your eye on. And that was just passed on June 25th.
And I will say, as well, as a client of NCW and Sanford Tatum, you do have access to a resource that we have that I do have access to of a video for diversity inclusion. So if you have, if your office is interested in having your employees partake in that, feel free to email me and I can get you squared away on training for that. Stephanie, can you speak more to the customer permission that you mentioned to use their email for email blasts?
Yeah, so if a customer comes back and they state that they're getting spam mail and they didn't sign up for emails from a company, that violates the CAN-SPAM Act. So a company, when you go and sign up for a newsletter, you check that box. I give them my permission to send me an email. That's basically what it is. If there's a fine line, because there have been companies that have said, well, they're a paying client, so they signed up for this. You can say that, but the courts have also ruled against companies that automatically enrolled their clients into an email blast list that is any kind of marketing material without them accepting it. So for instance, when you sign the client agreement with us, where you can call in and make phone calls to us, one of the things that we include is a section at the bottom talking about our newsletter and the name, email address, and phone number of whoever would want to receive it. And if they want the HR, the safety, or the DOT. And that protects us, because if we happen to still be sending you a newsletter and you're no longer an NCW client, you can mark that as spam and say you didn't choose to sign up for this. And we don't have any contractual relationship with you anymore because you're not an NCW client. But we may not have possibly been notified that you went to another insurance company. So it just is one more level of protection for us. And with everybody being so sue happy these days and every little thing, that's just something, one little small step to protect yourself. It could be something that you include in the invoices you send out to clients where, when they jump online, they can check this box if they agree to, marketing emails once a week or whatever from you all. And that just will protect you from them coming up and saying that you were scamming them. And with the new cybersecurity laws and regulations that are going into place, it's going to be a bigger thing, because people are very concerned and validly concerned that by clicking links within an email that's sent to them, they can open themselves up to cyber attack vulnerabilities, which they can. Clicking a link can do something as simple as open a script up on your computer that basically is mapping all the documents that you have, and it's a little pathway for a cyber security attacker to get into your computer and find your customer data. So
if a company doesn't have something like that in place, are you suggesting that moving forward, what is your suggestion?
If somebody wants to sign up for your newsletter, then simply ask them to send you an email requesting to sign up. And then just,
if an organization already has a newsletter going out, and let's say they have all these emails, are you suggesting starting over in that?
No, what I would do first is I would make sure that the email you send out has a way to opt out, and it should be a one-click opt out, or just to respond to this email and put opt out in the subject line. Okay. That's going to be the most important thing, because that's part of the CAN-SPAM Act too. Any marketing material that you send out, somebody should have a way to opt out, and it should be an easy way to opt out, not a complicated way. Something as simply as responding and saying opt out. When you want to make it easy for them, so they can't claim that they were just stuck getting this and didn't know how to opt out.
So that's good to know. So if someone has that in place, or if it says unsubscribe here, if you're not interested in receiving this communication anymore, email, that kind of protects you.
Yeah, and most companies are going to be using marketing, email companies like MailChimp or Robly or Constant Contact. And all those emails are going to have an easy opt-out so that they comply with CAN-SPAM. What happens too, and this is another reason why we want to make sure that we're getting permission to send emails to people, is on all of those emails too, when they click unsubscribe, they can choose a reason why they unsubscribe through those platforms at least. And if they choose, I never signed up for this email, if you get too many of those in one blast you send out, what it does is it red flags you, and they can freeze your account. And they can not only freeze your account, if it happens multiple times, they can take your account away completely, and you've lost all those email addresses if that's the only database you were keeping them in. I know I've had firsthand experience. So.
Okay, we're all learning new things. Does anyone have any other questions? Stephanie, do you have anything else that you're wanting to touch on?
Not really. We're going to hold off on discussing the dress code issues and updating dress code policies until we get some more clarification from the government. Just to give everybody a heads up, there was a lawsuit filed by the ACLU against Alaska Airlines for the disparity in dress codes between the male flight attendants and the female flight attendants. And they sent a 25-page letter to Alaska Airlines to basically cease and desist and update their dress code policy right away. And we're just waiting to hear the government's stance on that. But I have a feeling that that's going to be another change coming our way eventually.
Can you also, I know originally you were going to speak on the hiring challenges as boomers leave the workplace. Can you speak a little bit to that, or do you want to speak more to that in August?
I'll speak more to that in August, but I'll just give a brief overview. Okay. One of the reasons for the new diversity, equity, and inclusion requirements, and like I said, it's going to be passed to private employers, is because of the age gap in the workplace. You have very young people coming into the workplace, and then you've got a large, group of workers that aren't ready to retire, and the retirement age is getting older and older and older. And communication is key. There's a lot of communication issues and things that somebody says. The meanings of phrases are different among different generations. So when somebody in one generation says one thing and it's completely innocent, somebody in a younger generation is gonna be like, oh yeah, no, and they could take offense to it and you don't realize it. So one of the things about that DEI training is talking about communication among employees and between employers and employees and what's appropriate and how to understand sensitivity training too, and being sensitive to others' feelings, whereas things may not upset you and you may interpret them differently, but others are also going to interpret them differently and it may be offensive and upsetting to them as well. So that's part of the DEI training and the sensitivity training. Sensitivity in the workplace is the biggest thing. But we'll talk about like some recruiting challenges in the workplace in August, and how do you replace a workforce that's quickly retiring? Because you have a workforce that has tons of experience, and then you've got all these green employees that don't have the experience, and they may not necessarily have somebody to follow as a role model and in the workplace to get that work ethic. So that it's all hand in hand with the DEI. So I think we talk more about the DEI and we talk about the recruiting efforts and the age, differences in the workplace and things of that nature. That's going to be something that will tie hand in hand. So we'll make that just a big topic for August.
Perfect. And I do want to remind everyone, our Q1 seminar was over generational gaps in the workplace and the challenges that employers are facing with that. So Michelle McCarter did that seminar, and that is recorded and available. So if you're interested in watching that or rewatching that, let me know and I can give you access to that.
If you can send me a link, I'd love to watch it.
Yes, I will send it to you. It's great. So much valuable information. I will send it on its way. But as a reminder, Clear Up the Chaos takes place the second Tuesday of every month at 10 a.m. So mark your calendar and feel free to go ahead and go to our website and sign up for the next seminar. Save the date. It is taking place Tuesday, August 10th. So I hope you'll be able to join us. And if your schedule does not allow, feel free to go ahead and sign up. And then I'm happy to send you the recording with any supporting documents that are discussed. So you can watch that at your convenience. So like always, you do have access to Blakeman & Associates as a client of NCW and Sanford and Tatum. So if you have not signed up and are interested, shoot me an email. And like I mentioned, if you are interested in doing any of the trainings on diversity and inclusion, feel free to shoot me an email as well, and I can get your organization signed up for that. So
and if you guys have any other questions and you want to send it to Elizabeth, she can send it to me and I'll get them answered for you.
Absolutely. With no further questions, I appreciate your time and I hope you'll have a great week. Thank you, Stephanie.
Thank you.
Bye.